Article 8 of the IP policy, they talks about public health, nutrition, promotion of public interest, protection against unreasonably restrained trade, and against practices. He will elaborate more on this conceptual part if I read this presentation earlier. But I want to tell that, let us take TRIPS as a benchmark. What TRIPS says, because that is the document currently, a kind of a common minimum program, I would call it, on intellectual property rights, signed by sovereign countries. And of course, there may be other types of, I would say that opinions outside TRIPS, that it is free for countries or lobbies to talk about it, but nation states which have signed TRIPS need to be looked at whether they are adhering to TRIPS. So the TRIPS mandate, which again I leave it to Mr. Shegel, he will discuss much, so I skip that. It is also given very, very clear mandate under TRIPS what could be the standards and parameters. But much after TRIPS, Doha came. And in Doha, because there was a lot of problem in clarity of language in TRIPS in 1995. And we all know that as one of the negotiators of TRIPS from India, I asked him that, what was his experience when TRIPS was signed. He said, we couldn't realize much, but there was a toast. And then we took the wine glasses. Then we came back home in India and read TRIPS. Then we found out what we have signed. Is it good for us? So that kind of problems came with many people who are not experienced with international drafting of IPR, whereas certain countries were very experienced. So what happened? The Doha, which happened later, had only one thing. Each member has the right to grant compulsory license and the freedom to determine the grounds upon which such licenses are granted. This is given to the government. It is the government which decides how the access can be provided. Whether government is going to do R&D, produce its own medicine, give it to everybody, or government is going to intervene, it is, I would call it, loud and clear. I also want to point out, 15 Democrats wrote about this when a case came with, Colombia versus United States, when USTR threatened that they are going to cut off aid to Colombia because they were contemplating on compulsory license. 15 Democrats said it to Michael Froman that that is wrong, that United States need to follow and set an example of what they have signed, and they cannot do this to Colombia. This was very clear about Democrats writing to the USTR chairman. So, what does it mean? I give a quick snapshot. Canada, 1935 to 70, I won't be reading it. United States, I've given, year-wise, what the number of applications of compulsory license, how it has been happening in different countries, much before India gave way back in few years back. So United Kingdom, Germany, Israel, Australia, South Africa, you can call it in different levels. You can do a comparative chart and see that this is something age-old, not exactly something which, when India did the compulsory license, I'm sure there was a big hue and cry. So in India, 1972 to 2015, and Japan, no grant till date. So these are the comparative, things, I'm quoting from another media group which has made this comparison. So any kind of error in that is not typically what I'm doing. It could be something crept in if they've done it. But this is one way of trying to do a comparison. In the United States, not part of the codified law, compulsory license itself. However, refusal to deal is an essential element of intellectual property right. Anti-competition, which is antitrust laws, can be used, theoretically speaking. It's another question whether a situation has arisen, whether it has been practiced, another part of the story. U.S. other provisions. You have Bayh-Dole Act of 1980, which allows government to exercise margin rights with regard to government-funded research results that universities might otherwise patent. So government has a margin rights. U.S. has granted compulsory license when it felt public interest at stake. You have Atomic Energy Act, Clean Air Act, Federal Non-Nuclear Energy Research and Development. If you look at all this, you really find not exactly in Patents Act, there is no reflection, but you will find these things, or rather potential instruments which the government can use. Behind the Great Wall, there is China, Article 48(1), when it has been 3 years since the date of patent right is granted, and 4 years since the date of patent application is submitted, the patentee, without legitimate reasons, fails to have the patent exploited or fully exploited, is subject for compulsory license. In Canada, abuse of rights, if by reason of refusal of a patentee to grant a license or licenses on reasonable terms, refusal to deal is one important clause within Canada. The Japanese perspective, because I spent some time in Tokyo doing a comparative understanding between the Indian condition on compulsory license in Japan, you really find Article 93(1), which specifically uses the word public interest. It says, where the working of the patent is necessary in public interest, a person who intends to work the invention may request the patentee. If no agreement is reached or no consultation is possible under the preceding subsection, a person can approach the Minister for International Trade and Industry. They are not granted so far. That's another part of the story. What I understood that there are a lot of applications which have been filed, about 15 to 20 applications, but they have worked a compromise. They have worked a kind of compromise, which is also part of the Japanese style of working, not much getting into litigation. They worked out a compromise with the industry and with the applicants. So in India, I need not tell, I think it was well explained by the moderator in the beginning, under section 84(7) of the 1970 Patent Act. And then this is the Japanese perspective. As I said, I don't want to skip much of this. As I said, there's one more issue called exclusive grant back or coercive packaging licensing. Legal in the past, granted in Transport Wrap Machine Corporation versus Strokes, but discouraged, interpreted by the rule of reason doctrine, which is an interpretation of the Sherman Anti-Tracts. But since 2007, the Department of Justice has directed that it should be non-exclusive under its antitrust laws. Earlier there was no mention, now it has become part of the antitrust laws. Other jurisdiction, Canada, not applicable. In India, again, 84(7)(c), it talks about grant of license under the patent to provide, exclusive grant back, prevention to challenges to validity of patent, or coercive packaging licensing. These are all could, result in applicability of, the grant back license, or in another way, I'm looking at compulsory license. And then hindered by importation from abroad. If, in US, nothing is available, Canada not available, but in India, if the working of the patent invention in the territory of India on a commercial scale is being prevented or hindered by the importation from abroad of the patented article, patentee, persons purchasing it and other person not taking proceedings for infringement could be a cause of action. In China, nothing is available. Dependent patents, again, a patent, and then there is a dependent patent. In the United States, we don't have any provision, but US does have formally codified a general provision for compulsory licensing of dependent patents. In Canada, still not available. In India, again, it's much clearer in section 88, where it says, under those patents without infringing the other patents held by the patentee, and if those patents involve important technical advancement of considerable economic significance, may direct grant of a license. So you find variations in few countries and reflections in few countries. In China, again, if an invention, utility model represents major technological advancement of remarkable economic significance compared with an earlier invention or an utility model, and exploitation of the farmer relies on the exploitation of the later patent, it may grant a compulsory license to exploit. So I'm not looking at a straitjacketed order of a compulsory license. We are also looking at various other aspects which are also touching upon how governments will intervene at circumstances, at situations. It will depend upon the case law, it will depend upon the context where it is intervening. That is, the nitty-gritty is left. But we are talking about a broad roadmap about the importance of compulsory license and public interest, which is very acute as far as public health is concerned. Because I think that I have a choice to use an iPhone, or I do have a choice to use, any other phone to talk. But drugs is not my choice. Drugs is not my choice. It is not something which created for myself. And so obviously you find this very acute, especially when it comes to, medicines. And obviously we also know other side, the whole patent regime hinges heavily on the practice of, drug discovery, other things, because, as you said, return on investments is heavily because of the investments are very high there. So you are really talking a catch-22 situation in one sense, that as the moderator pointed out about one part of the investment, on the other part of the access. Only thing I deferred that government will use many other tools to do that, because remember, I need to be elected after 5 years, right? So that is another part of the story where my public interest is very much felt on the ground than any private entity. So comparative analytics, in my opinion, India is well within the international law as far as awarding CL is concerned. I'm not getting into the specific issue. as a 3-tiered judicial review for patent holder to get remedies. You got IPAB, you got state courts, you got a Supreme Court. There is definitely a mature judicial system which is there. And most importantly, don't trust any of them. Dispute settlement body in WTO is there for anyone to approach about any particular case. So there it is quite what you call as, it's a kind of a jurisprudence which has been developing for quite some time, and it has been well structured. So where does the whole thing comes from? Sometimes I find, as the American philosopher in cognitive science, he said, use the word qualia, which means an unfamiliar term for something that could not be more familiar to each of us, the way that thing seems to us. So very interesting why I said this. When Japan, when time and again I spoke to professors, many people, they said, what is public interest? In a sense, they said private interest is public interest, because they felt it is working well in Japan, that they trust, a private run, Shinkansen, that is the bullet train, than the government run train. Am I right? So it could be reverse in certain other jurisdictions where they will be really talking that, their trust is still better with a government than with, private entities running things. So it's a kind of a division where it's very difficult to meet at a point about what we are really looking and trying to get a universal model on this, because, as I said, our honorable moderator gave about the percentage of GDP, etc., in terms of that. And we also have to look about, the overall countries, capacity to do certain things definitely makes a point in terms of how developing countries are going to look at the evolution of IPR. As I said, now the main problem is WTO is like, in my opinion, a boxing ring, right? It's a boxing ring. There is a fight going on. But we are talking about other types of plurilateralism like, trans-Pacific trade agreements coming in, right? And will it derail even the multilateralism will again take to, smaller things? That will be a crucial question. And I don't know the answer. Only Trump has the answer on January 20th when he comes, what he's going to do to TPP, right? Or he's going to tell, no, I never spoke about TPP. It's a fake news, right? He's going to tell, I really don't know. And as I said, in my opinion, to conclude, CL is not the danger. CL is not the danger. It is the fire extinguisher, right? It's not the danger. It's a fire extinguisher. All of us have fire extinguishers everywhere. We don't use fire extinguisher every day, but we know that it has a use. Thank you very much.